Hello, everybody. We are going to discuss how to put together a land trust. A land trust is very important because it allows you to take title to your real property. I don't like to say real estate. Real estate is taxed. Real property is not, according to constitutional law. So I'm going to show you my day-to-day or monthly use of a land trust that I use. You may use it in any state that you are accumulating properties. Um, this is for investing purposes, or it can be, well, let's just leave it at that, investing purposes, because if you were to use your own personal residence where you currently sleep, where you lay your head, um, I've always talked about utilizing two choices, either a land trust or the express trust. If you do not plan to sell your property and you want to leave it in the trust for generations to come, and you do not want to sell the property at all, then you may use the express trust. And you know that your express trust is good for a 25-year interval upon the death of the settler. And once the death of the settler takes place, knock on wood, we want to live forever. But if that takes place, the trust then becomes immortal. And so you better have the right fiduciary or the right trustee to carry out the wishes that you have worked so hard to accumulate within your trust, to pass on to the next generation, so that way it is not squandered and the counties do not recollect that which they used to have before the trust took it over. If you do plan on selling the property at some point for capital gains, to take on that equity that has been accumulated over the years, or you want to just rent out the property, or maybe do a lease option, a lease purchase, options, whatever you want to do as far as investing purposes, and you're not going to live there because the insurance will state that, then you would utilize a land trust. A land trust does not require an EIN number from the IRS. You're simply using this entity to take title to the property. From there, you will have specific entities that I've shown in that real estate empire chart. You may use different entities to sign off on the land trust as the trustee. Okay. Now, am I saying if you put this in the express trust, you can't invest with your property? No, I'm not saying that. If you put it into the foreign express trust, they're going to ask who is the trustee. That's the only one that can sign off on it, which you guys have your foreign trustee from another country. So they're not going to be present or able to sign off on any of the county documents if they're not here within the United States. So that's why I recommend you utilize a land trust to do such things with the property. Okay. So let's take a look at the land trust document. And as you see on my screen here, I have the Delaware Code online to show me the Constitution of 1897. It's going to take some understanding of your Constitution when it comes to doing the land trust, because you want to find exactly where it talks about taxation and county tax assessment exemption. How does it work in your state? And we'll get to that very soon. So here is the land trust. I'm going to go over a few sections. You will have the exact Word file, so that way you may make any changes to it that you need. In this example here, I first learned this from a great grandfather of real estate, Mr. Ron LeGrand. I went to a few of his seminars across the country and learned this information and utilized it for myself, and it does work. You may want to befriend a real estate attorney who can close out on these type of transactions if you're looking to acquire a real estate empire, right? So you can have that freedom that you want. Real estate is a good way to do that. I should say real property. I correct myself. Real property. I have to train my brain. Real property, real property. Real assets is what we're after. So when it comes to naming your trust, because you need to name it, because let's say I have on this boulevard, I have 3 houses. I'm not going to use ABC Land Trust for all 3 houses. I want to make some type of delineation between all 3. So on the first house, I'm going to call it 007 Bond Street. That's the name of the street, and that's the house number. And then I'll put the words Land Trust right after it. The house next door will be whatever I want. Let's say it's 008 Bond Street. And the third, 009 Bond Street. You get the picture. Now, each of these land trusts for each piece of property, it must have a trust number. I recommend it be anything that you want. It could be in correlation to your trustee minutes. The little identifier that we put in the left-hand corner, you can use that. But I recommend you make up something and have it cross-reference with your trustee minutes number. For example, if I put together trustee minutes number 15, it says Schedule A, trustee minutes number 15, and I'm talking about this land trust. In that minutes, the trust number I'm going to pick is XYZ_1 hashtag. You get the idea. So that way they link together. So you have to have a trust number. Very important. It's an identification number. So that way the courts can pull it up and match it with other trusts that are connected to this land trust. Because remember, even though you're not taking title to the property in the express trust still has its hand in this matter. It is lording over this land trust. So we give it some type of identification number to link it to something else. That way they know this is true property that is not theirs, and it never will be. Okay, so let's read. It says this trust agreement dated, whatever the date is, and known as trust number, whatever that number is to certify that ABC Corporation, a Delaware 501c3 religious educational entity. See, I've decided to use one of the corporations that I've made in Delaware for anonymity, right? You have to get a court order to find out who is associated with the actual companies registered there. And it is a 501c3 that my trust controls, right? So I have to put religious or educational because that is what the state of Delaware supports. Just those. Charity, religious, and educational. That's the only thing that it supports. Other states supports literary. They support many different things. I'm thinking of Georgia, right? They have so many different categories you can utilize for a 501c3. But in Delaware, it's just these 2. Now, you don't have to use a Delaware company. You do not have to use a 501c3. You can use ABC LLC if you have one, which is a company within that state, or it can be an unincorporated association, right? Or it can be a corporation within your state. So any one of these are going to be listed as the trustee. So ABC Corporation, holding and exercising trust powers, hereinafter referred to as trustee. is about to receive an interest as trustee in a certain parcel or parcels of real property. If you find anywhere in this document that says real estate, please change it to real property. I might have left a little Easter egg for you. You must read everything, word for word, comprehend it. Let's go over number one, the establishments of trust. When trustee has taken title to said real property or to any other real property or interest therein, transferred to it by recorded or appropriate instrument as trustee hereunder, it will hold it for the uses and purposes and upon the trust herein set forth, provided, however, that any property interest conveyed to trustee without trustee's prior written acceptance of said transfer will not be subject to this agreement and will not be deemed a valid and effective transfer of title to trustee. The trustee is protected by Delaware Constitution of 1897, Article 3, Education section, subsection 3. Now, if we go there on the Delaware Constitution, it was Article 3, was it? Article 10, actually. We go down to Article 10. See, this is what you have to look through in your Constitution. Find that section that is talking about taxation, which is here. It says, no portion of any fund now existing or which may hereafter be appropriated or raised by tax for educational purposes shall be appropriated to or used by or in aid of any sectarian, church, or denominational school, provided that all real or personal property used for school purposes, where the tuition is free, shall be exempt from taxation and assessment for public purposes. But Avery, I'm not teaching no school. I don't have a bunch of kids in my house. My kids go to school. I wish I can homeschool, but I'm not doing that. What do we do? They just gave you a big out. Now, some of you are homeschooling. Some of you may have daycare at home. Some of you may not. You may not have the time to do it. Why not do it? Why not homeschool? Why not train them at home in something where the tuition is free? Do something for educational purposes if you are in Delaware. If you're in another state, like I said, there's other things you can do. What we are learning here within the 0%, in their eyes, is considered educational purposes, even though it's the education that they don't want us to talk about amongst each other. And it is also considered a church. A church is not a building, it is a body of people. That's what an unincorporated association is, where two or more come together. That is a biblical treaty. That's exactly what it is. If we were to look up that definition of an unincorporated association, that says whenever two or more people decide to work together to accomplish a common purpose, they formed an unincorporated association. Now watch this. And as more commonly happens, if that common purpose is to accomplish some social or public good, they have formed an unincorporated nonprofit association. Don't worry about this word here, nonprofit. In both cases, no legal paperwork needs to be drawn up or filed for the organization to be considered an unincorporated association. So in the unincorporated association video I gave you, I also gave you the documents such as the bylaws to put that together. I still want you to do that despite them telling you you do not have to have legal paperwork. I'm telling you from experience, if something was to happen and you go to court, you need to have something in your back office, not just two people coming together on a verbal agreement. So please do that. Now, an unincorporated association is a church. I'm sure you can find some purpose to do in your home space to deem your home space worthy enough for this exemption. If you have children in your neighborhood and you want to teach them something, and the parents agree that you come use your house for that purpose, that's an exemption opportunity. It's really that simple. You just have to make that declaration and create your 501c3 entity for that purpose. Let's talk about Section 2, the beneficiaries. We have to identify the beneficiaries without identifying the beneficiaries. How about that? It says the following named persons and their successors in interest shall be entitled to the earnings, avails, and proceeds of said real property or interest therein, according to the representative interest herein set forth, to wit. That means to witness. The 12 Houses Unincorporated Association, that is one of my unincorps based out of California. When I did it in California, luckily or fortunately, Secretary of State California had a form to actually file it. Now it used to be a private filing, but now it's made public. But you can make yours out of California and simply bring it into your state's jurisdiction by filing what? Think about it. What do you have to file to bring something from one state to your state because your state doesn't have a form like this? What would you do? That's right. You would do your affidavit of fictitious business name, trustee minutes, and simply put such and such express trust doing business as unincorporated association, and another one, which would be what? This land trust name doing business as such and such unincorporated association. Now the address, the principal address will be in California, but the mailing address will be in the state that you want to use it in. That's how you bring it from one state to your jurisdiction. All right. So this is mine, 12 Houses Unincorporated Association is going to be listed here as a beneficiary. And if anyone wanted to know who was benefiting from this company, they would have to find this information here. Now, I don't have to necessarily say a California association. I can take that off, right? Let's not make it easy for them to do searching. But you can use any entity you want. If you want to put your name down, if you want to put your children's name down, you can do that. If you want to put a business or charity that you want to have reaped the benefits of this trust down, you can do that as well. Any entity can be a beneficiary in a land trust. So 12 Houses Unincorporated Association and the beneficiaries are about to convey or cause to be conveyed to the trustee as trustee hereunder, title to the following described property situated in Newcastle County, in the city of Wilmington, in the territory of Delaware, one of the several states of the United States of America, more properly known as, then you would list your parcel number there and the legal description. It would go something like this: in this lot and plat map of Newcastle County, in the city of Wilmington, 75 acres northeast to the 32.94 acres west side, adjacent to the main river. Look for something like that in your your deed, your warranty deed. It will have the entire short form or long form legal description, and you must put that here. Now, I take it a step further. I also add the earth coordinates, latitude and longitude. You can go to gps-coordinates.net and enter any location you want. Let's say we want to find the Staples Center, and it will pull up the coordinates for where the Los Angeles Lakers play. Okay. So moving on, it is understood and agreed between the parties hereto, and by any person or persons who may become entitled to any interest under this trust, that the interest of any beneficiary hereunder shall consist only of one, the power to direct the trustee to deal with the title to the property, the power to manage, possess, use, and control the property, and 3, the right to receive the earnings, avails, and proceeds from leases and other uses, and from mortgages, sales, and other dispositions of the property. Such interests shall be personal property. All right, let's scroll down. Let's go to number 4. Let's talk about the power of discretion. It says the trustee will deal with the said real property or any cash or property or assets of any kind that may come into possession or control of the trustee as trustee, hereunder only on the written direction of the party or parties designated herein as having the power of discretion. The trustee under no circumstances has the power to reveal the identity of the beneficiaries. Mortgages or trust deeds executed by the trustee may include a waiver of any and all rights of redemption from sale under any order or decree of foreclosure or such mortgage or trust deed. Trustee may demand indemnification from the power of discretion holders or not be required to inquire into the propriety of any direction. The power of discretion shall be held by none other, the beneficiary. Let's go down to the duties of the trustee. What can they do, right? Very important. What are they going to do? It says nothing contained in this agreement shall be construed as imposing an obligation on the trustee to file any income, profit, or other tax reports or schedules, it being expressly understood that the beneficiaries from time to time will individually make all such reports and pay any and all taxes required with respect to the earnings, avails, and proceeds of said. Ooh, you guys caught it, didn't you? Or growing out of their interest under this trust agreement. Trustees shall not be required to enter into any personal obligation or liability in dealing with said land or to make itself liable for any damages, costs, expenses, fines, or penalties, or to deal with the title as long as any money is to due to it hereunder. Trustees shall have no duty in respect to the management or control or the collection, handling, or application of such rents, earnings, avails, or proceeds, or in respect to the payment of taxes or assessments, or in respect to insurance, litigation, or otherwise, except on written direction as herein above provided. And after the payment to it of all money necessary to carry out said instructions, trustee shall not be deemed a guarantor of any signature of any beneficiary, and trustees shall have no duty to ascertain the genuineness of any signature other than through the exercise of reasonable care based upon land trust industry standards. The trustee shall not be required to execute any instrument containing covenants of warranty. A. On the written direction of the beneficiaries of such other persons or persons as shall from time to time be designated in writing by them, the trustee shall execute all instruments which shall be necessary to protect and conserve the property, sell, contract to sell, and grant options to purchase the property, and any right, title, or interest therein for cash or on credit. You see, when it says on credit, that means you can sell the property like you are the bank. That's a seller finance transaction. You became the bank, you gave them credit, and they're going to pay you X amount of dollars per month, plus interest, most likely a balloon payment, and it will be over the course of 30 years. Exchange the property or any part thereof for any other real or personal property upon any terms. Convey the property by deed or otherwise conveyance to any grantee, with or without consideration, mortgage, pledge, or otherwise encumber the property or any part thereof, lease, contract to lease, grant options to lease, and renew, extend, amend, and otherwise modify leases on the property or any part thereof from time to time, for any rental and upon any other terms and conditions, release, convey, or assign any other right, title, or interest whatsoever in, to, or about the property or any part thereof. The trustee shall not be required to inquire into the authenticity, necessity, or propriety of any written direction executed and delivered to it by the beneficiaries or their designee or designees pursuant to this paragraph 6A, provided, however, that anything in this agreement or otherwise to the contrary notwithstanding, any beneficiary who is not as a designee of all the beneficiaries vested with the power of direction hereunder may, by a written notice delivered to the trustee, prevent the trustee from executing an instrument affecting the title to the property except upon the written collective direction of all the beneficiaries. You see, we try to cover everything in these trusts here, everything. I'll go ahead and let you read section B. Let's go down to section 9. Indemnification of the trustee. I'm going to start right here. It says trustee shall have a first lien on all trust property for all monies due it under the terms of this agreement. Beneficiaries and each of them agree to reimburse, indemnify, and hold harmless ABC Corporation, that's the trustee based out of Delaware, its officers and employees, both as trustee hereunder and individually, from and against any and all liabilities, claims, obligations, losses, damages, penalties, actions, judgments, suits, costs, expenses, or disbursements of any kind or nature whatsoever, including those which may be incurred on account of any laws and regulations relating to environmental protection, which may be imposed on, incurred by, or asserted against ABC Corporation, its officers and employees individually or as trustee in any way relating to or arising out of this agreement. All right. Section 10, you should be familiar with bonds. Just like in Section 9, you should be familiar with the hold harmless indemnity agreement between you and your foreign trustee, right? Remember, the trust is indemnifying the foreign trustee from all of these things. Same way here, you will indemnify, the beneficiary will indemnify the trustee in the land trust. Now with the bonds, it says to further protect the trustee against any loss or liability which may be imposed upon it by law, the beneficiary shall, during the continuation of this trust, carry public bond covering the trust property with an insurance company approved by the trustee in the minimum amount of $200,000, and all such bonds shall name the trustee as an obligor. Now, the insurance company here is most likely going to be who? That's the surety. That's the one who's going to pay in the event that your trustee has to file a lawsuit against the beneficiaries. But that's not going to happen, right? You do not have to have it $200,000. It could be whatever your trustee will approve, will allow. That means the maximum that he's going to get in the event that he has to sue the beneficiaries for a wrongdoing. Like I said, it's not going to happen, but just do it anyway. This makes the contract more valid. There's also going to be insurance. The beneficiary or beneficiaries shall cause trustee to be named as an additional insured under all insurance policies insuring the trust property. This has to be done because if you are to rent this property out, therefore you're not living in it, so it is non-occupied by the owner. It's non-owner occupied, so that means this is an investor insurance policy. So the trustee is the one signing off on this land trust. And in trust law, you guys know it, we always say the trustee is looked upon as the owner. So that's the one that needs to be listed on the insurance policy. This is a gem for those who are asking about how does insurance work and how does bonds work for automobiles. The very same way. Let's go down to section 23. What about income taxes? The trustee shall not be obligated to file any income tax returns with respect to this trust, but the beneficiaries shall individually file all such returns and pay all taxes on the earnings and avails of the property or growing out of their interest hereunder. So this is the sneaky part that wealthy individuals use right here. So let's go back. It says the trustee shall not be obligated to file any income tax returns, right? They are exempt from that individually. Look at 24, trustee not individually liable. So the land trust does not have an EIN number. So who else has an EIN number? The beneficiaries. The beneficiary is ABC Corporation based out of Delaware, and it has an EIN. So that EIN can avoid having to file tax returns on the earnings of this property. How? From the entity reclassification process. Form 8832. Remember, that's the one that's going to be responsible for tax forms. But if you take care of your beneficiary, the 12 Houses Unincorporated Association, and its EIN on the 8832, and you push it hard until the IRS gives you your approval. Do not take a rejection for an acceptance. You will eventually get it. But once you have it, this land trust does not pay taxes on its earnings. So let's say you sell the property and you take on $100,000 of capital gains. You don't pay on those taxes right away. They expect you to file it at the end of the year. And someone else is going to report on that transaction, right? Because escrow is handling it. Well, as long as you have that 8832 approval by that time, you're good to go. You are good to go. Look at section 26, compensation of the trustee. The beneficiaries jointly and severally agree to pay the trustee as its compensation the following. That is completely between you and the trustee. How much do they want to be paid for their services? That all depends on what you're going to have them do, right? Are you going to have them deal with landscaping every month? Are you going to have them deal with the fixing a toilet every month for your tenants? It all depends. You can actually put the management fee every month, which usually is anywhere from $500 to $800, depending on the square foot, and let that be the compensation rate of the trustee. But the two of you will have to work it out. In section 29, governing law, this agreement shall be construed in accordance with the laws of the state of Delaware. Why? Because my trustee is from Delaware, but actually in this example, I'm pretending that a property is in Delaware. So that's why I'm making the governing law to be Delaware. It has to be where the property is, okay? All right, so this document will be available to you all on the site in Word format, so feel free to use it. I use it quite frequently. This is bulletproof. You can have it. Down below, we have a witness page. So if ABC Corporation out of Delaware is going to be signing off as the trustee, you want to have your president sign off. You want to have your corporate secretary be a witness to that sign off, and then also provide the one who's going to be receiving any bills from the county, anything pertaining to the property, who's going to be the one to receive information. It's best to just use your registered agent of your company that you're using. Again, if you're using an LLC, put the manager here, put the second manager here, and then put the registered agent here, the LLC. Same thing for standard corporation, okay, across the board. And down below, you will, on the last page, add your beneficiaries information. So it will be the president of ABC Corporation. He signs, he types his name, he puts his address. Please put an iPostal address, not where you sleep. Do not put your social security number, put the EIN number to the business, the office number. There usually isn't any ID information here unless you want to give your final passport information. You can do that. But nothing with driver's license, no state ID, no gun, certification, firearm ID. It needs to be passport. Passport is the best one. Or you can use your birth certificate, okay? Your authenticated birth certificate. So ID information would be the authenticated number right here, the issue date, and there is no expiration. So you would put 99/99/9999. And then you can put your date of birth. All right. If you guys remember, I talked about this here on how to properly identify a beneficiary in your trust. We talked about the trust certificate units. You have to use birth certificate information to put on the unit, and that would let the courts know who exactly is going to get 14% or 15%, 90% of whatever is the asset we're talking about in that particular property. All right, so with that being said, that's going to be it. This was the land trust little webinar. You will find the document on the site. If you have any questions, feel free to comment and leave suggestions inside of the comment section. And I will see you all on the next call, whether that is on the first Saturday of September for you or the 15th of Saturday of September. I'm sorry, the 15th of September if you are a private client. See you guys next time.